audio recorded for playback on YouTube. I will now ask that you rise. The Pledge of Allegiance. Oh, I should say it was 9:15 a.m. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Present today in the hall, Nancy Goulart. Online is William Moore, and we're waiting to hear from Eric Easterday, but we have a quorum, so we're going to proceed. Also in attendance is Mrs. Kane and Mr. McKeon, two property owners, and Ms. Quirk, the daughter of Mrs. Kane, who is trustee to the Kane estate. Also Mrs. Schechter from the assessor's office, and also Ms. Valerie Wilson from the Board of Assessors office. Mrs. Schechter is going to have to leave shortly, and so Mrs. Wilson will be here to help us from the fence viewers assessors side of this. Mrs. Schechter, you want to start?
So I guess we're just trying to find out what the status of contract and everything. I know, do you just want to start? Do you want to go through the contract or?
Well, Laurel has one question about the contract.
Has it just been rewritten?
Excuse me?
Has the contract been rewritten the way it was sent to me yesterday? I can't sign that. Individually needs to come out of there before, at the beginning. It says, it's right in the first paragraph. It says individual and trustee. It's just the trust that's signing this contract. It's not, I'm not.
Are you saying that only your mother and father would sign?
Nope, I'm signing. I am not taking like responsibility. So off of some guidance I had received from my husband after reading this over, he and I, out of protection to ourselves, would like to see individually come off of the document.
So Nancy, if I may, so we discovered that the Kane Family Trust consists only of the Kane children, does not consist of any of the residents of the property. So therefore, they do not need to sign. The only person that needs to sign is the Kane Family Trust, which is, Laurel is the trustee. What she is objecting to is the wording of this contract that says that the trust and her personally would be liable. At that point, I'd like to ask Mr. McKeon if he has any objection to removing the individual part of it.
Well, I'd like to stay. And I put this out there a while ago, and we're just finding out about this objection on the date of the meeting. This agreement's been circulated for weeks, if not more.
So this is just an update, and we're just hearing about an objection ourselves. This is new to us as well. If we don't get past this, this is going to be an impasse. What is your objection to removing her personally being liable?
I think she has to stay on it. That's my reason. And I think the impasse here, Mr. Chairman, is this. The committee has been in a position to make a final decision and order probably since September. In an effort to try to settle the matter without the committee making a final decision or judgment, I have circulated a proposed settlement agreement between the parties. This has been delayed many, many times owing to the wrong representatives appearing at this meeting. It's been delayed because the terms of the Kane Family Trust haven't been made known until fairly recently. And there have been changes made at the request of this committee, presumably with consultation to the trustee. And per my email of about 2 weeks ago, I indicated that should Ms. Quirk appear at this meeting today and sign the agreement, both my wife and I would sign it. Today, for the first time during the meeting, we find out there is an objection to it. As a result of a settlement impasse, this puts the matter back into the committee's lap to make a final and binding decision on the parties. I would suggest that that's where it is now. You've had all the opportunity to hear evidence, review documents, make site visits, hear the input and argument of all the parties involved. And frankly, there really has been nothing new for you to consider since probably September. A lot of effort's been done on our part to try to bring this matter to a resolution between the parties, but that's not possible. So I would ask that the committee make a final and binding decision. Thank you.
So my opinion hasn't changed, as Mr. McKeon said, since months ago. I believe we don't have any right to change the marker. We can order that the fence be moved. What are your feelings, Eric and Nancy?
Nancy?
Quite frankly, I'm very disappointed. I thought today was going to hopefully resolve all the issues. I was not aware that the word individually was going to stop this. The fact that this is a legal trust that's been set up, in my opinion, since I have a trust myself, protects those in the trust and those acting on behalf of those who set the trust up, as long as you follow the law. This isn't relative per se to the actual trust. The trust gives permission for Mrs. Quirk to act as indicated by her parents when they set it up. I don't see a legal liability on her case relative to moving ahead with this agreement. I thought we made great progress to find out last night by an email that we weren't going to be able to finish this up today. I mean, we agreed on everything. The whole dispute was the boundary line. Can we get the stone wall fixed? And both parties, all parties, either side of the stone wall agreed to split the cost and everything else. That's been done. The stone wall running east-west, the base stones are there. So you put the stones that fell over on top of them. And as far as the north-south boundary, the deeds indicate 78.2 feet from a medallion, which it's been measured, and the parties that live on these properties agree. And the email referenced financial burden and having to get a surveyor in there. Well, if anything, hiring a surveyor, again, is a financial burden to put on anybody. And I would assume that would be on the Kane family. I don't see the need for that. So I'm
if
very
I may-
disappointed.
If I may, Nancy, if I may put some words in Laurel's mouth, she's not disagreeing with any of what you're saying. The only issue she has is with that one, the word individual, which saying that she's individually liable for something that goes wrong on this contract. And I honestly can see her position there. At this point, I would ask Mr. McKeon to take that word out. And with the exception of that word, I think we have an agreement. And if we don't have an agreement, then this board is going to have to act without an agreement.
I'll just move forward. I just need that individually taken off the document. My parents made this agreement. Unfortunately, me being taken into consideration wasn't taking into consideration as the trustee to the estate. And with the agreement that my parents have made, I will proceed forward, but I need individually to be removed from the document. Other than that, I will sign the document.
So again, I ask you, Mr. McKeon, please, can we take the word individually off?
I didn't see the document until last night. It was never sent to me until just last night.
And I'd like to apologize to you that, we did not realize the makeup of the trust. So therefore we were not communicating with you.
It was a little, it reads a little funny when you pull it up online, but once you do get all the paperwork.
Yes, once we got the trust, we understood that you're the person in charge, and we didn't know that at the time. So please forgive us for not working directly with you. So anyways, it's in Mr. McKeon's court. If he wants to settle this, he can. Otherwise, we have to make some ruling without moving the post.
Mr. Moore, with all due respect, putting it back into, I have been drafting this agreement, forwarding it to this board, which I presumed forwarded it on to Kane's at least weeks, if not months ago. It's absolutely unfair.
We did, but understand that we were forwarding it to Marguerite.
Why didn't she send it off to the trustee? If it's their position that the trustee is the one that has only the authority to act on behalf of the trust.
This is only recently came to light.
Mr. Moore, if I may finish, why is it that we are finding out about this either last night that there was a problem, which I didn't find out about until this meeting? This is all the importance, because I don't think they know how to operate as a trust, and that imposes all the more reason to have individual responsibility that this gets done. What is the problem with having the word individual in there?
It puts the responsibility on me rather than on the trust. And I take, as the trustee, I take responsibility, but as an individual, I do not take responsibility.
So what is the individual responsibility that you find problematic?
You've come to an agreement with my parents, and I will abide by that agreement because out of respect for my mom and dad, I happen to disagree with what they've come to terms with, and that's okay.
See, there I have a problem. If you're not in agreement with what has been written up, I have a real problem with your willingness to sign this.
Nope, I am more than willing to sign this agreement. I wish to take responsibility off of myself and just keep it the responsibility of moving a marker on the trust.
It's more than that. The trust has to pay for it.
I understand that.
Right, Bill, can I ask a question? I'm sorry, I don't mean to interrupt, but just a clarifying question. So individually, does that mean she's responsible outside the trust too? Or if there's any issue a month from now, 6 months from now, a year from now, you can say, well, it's not the trust fault, it's Laurel's fault. So I'm going to go after her personally and not after the trust, because she's a representative of the trust. So I'm just trying to understand the clarification there. So I understand her uneasy and I understand you're wanting it to be there, but
every single time any entity such as a corporation or a trust signs a legal agreement, even like a mortgage.
yeah, legally binding document. Sure.
The president of the corporation not only signs, but he has to sign in his personal, because if the corporation goes bad, the bank wants someone to be responsible. I have no idea if the trust, the Kane Family Trust, has any financial assets whatsoever to pay for this. Okay?
Right.
So if, for example, the contractor comes out, does the work, presents a bill for $900. okay?
Mhm.
And I send the bill off to Ms. Quirk in her capacity as trustee.
For the trust to
And
pay.
she says, I don't have any money in this trust account.
I see.
What do?
You want to make sure it gets
I
paid.
want to make sure it gets paid,
I see what you're saying.
okay? There has to be some personal response, and then she'll say, go ahead and sue the trust. All right, so then you know what I have to do? I have to sue claims court, put a lien on the property, and then wait for the property to get sold years down the road. Okay? That's, and if she has a real problem with putting up the $450, you know, that's the individual.
I think she's worried about future liability. I don't think she's.
You know,
No.
Anyway, I can't speak for her.
wait a minute. I'm gonna go back to what I said, the powers and duty of a trustee. Okay, I have one. I'm aware of what my son's obligations are. I want to read something. This is the certificate of trust. This is clause 6. We know it authorizes Mrs. Quirk to take the action described in here. Clause 6. No person or entity paying money to or delivering property to the trustees shall be required to see its application. All persons relying on this document regarding the trustees and their powers over trust property shall be held harmless for any resulting loss or liability from such reliance. A copy of the certificate of trust shall be just as valid as the original. She is not going to be held liable because this clause, this is, she signed this.
But,
This-
no, so we're
You're saying not
straying
personally
into
liable.
lawyer.
So he can't lien her property in Rehoboth. I see she's from Rehoboth, right? He can't lien her property in Rehoboth as a result of acting on behalf of the trust, is what you're saying that line says,
I read it.
right? I mean, we're not
Okay.
attorneys. We don't have law
So-
degrees.
That's not, that's.
Hold on, please.
I'm asking.
Respectfully.
If I may.
That I am allowed to rely on the trust, that she is the trustee.
Right.
That's fine. I agree that she's the trustee. I want protection in the event the trust doesn't perform. So if the trustee says, I don't have any money, I can't pay, nobody has put any money into my trust account. All I know is the only asset in the King Family Trust is a building.
Is the house.
That's it. All right. So what protection do I have entering into a settlement agreement? You know, this committee has.
So
no
what if,
authority-
hold on, please, if I may take the floor, Black. First of all, Nancy, the document you were reading is the trust document. If Ms. Quirk signs a new document, that's going to supersede the trust document. And yes, she would be individually liable for something. Mr. McKeon, if your entire
She
concern,
can't relieve herself of actions that have been taken in the past.
excuse me, I didn't
Go
quite
ahead,
get what. So Mr. McKeon, if your entire concern is who's going to pay for this wall, how about if we just put money aside or make money as part of this agreement that the trust will provide the money up front? Would that satisfy you?
In part.
So if we can agree to put the money up front, we could take the money, the word individual out.
So, yeah, I mean, so then
They're
that,
in charge of this.
what is that? Okay,
We require everything.
She's gonna leave.
okay. Yeah, so if the trust puts up if it's $900, as you had stated, puts up $450, puts it in some sort of either escrow account or it's a cashier's check or something. That solves the problem of responsibility and it's there. And then it takes Laurel off the hook to say, hey, you're not gonna lien my property in Rehoboth because we didn't put up $450.
Additionally, on the bottom of page 2 of the agreement, there is a paragraph that actually, in my opinion, applies to Ms. Quirk personally, that she has to personally guarantee that there have been no, that she's the sole trustee, that there's been no changes, et cetera, since its original
She's
execution.
guaranteeing that this is the document that still exists and there's nothing since then.
And that there's been no assignment of power of attorney, that she's,
She can still act as trustee is what you're at. Do I understand that correct or no?
I think she needs to look at that paragraph in a personal capacity to guarantee that nothing has been changed relative to the trust.
Nothing has changed relative to the trust.
Okay, well, if you're comfortable with the fact that nothing's changed since then, and we come up with $450 or half of whatever this is,
We can come
Upfront.
up with $450 today, like it's not, coming up with the money is not an issue.
right?
Mr. Chairman? Mr. Chairman,
Yes, go ahead.
I'm going to read that last paragraph that was just referenced, since not everybody sitting here has this document in front of them.
Thank you.
Paragraph on page 2 says, Laurel Quirk hereby certifies that she is the sole trustee of the trust, that she has not been removed as trustee. There has been no revocation, amendment, or change whatsoever to the original terms of the trust. There has been no assignment of power of attorney by the trustee, that she is fully empowered to solely execute this agreement under her powers as trustee, and that no legal action has been initiated to remove her as trustee.
What he's saying is there could be a superseding document after that that changes that. So she's saying no. She's confident that that's the case. He's worried about not being able to get paid for whatever the half of the trust is.
I
that's
understand that.
Going it down to
I
simplicity.
don't question the money up front.
Okay.
What I'm saying is, at the time she exercises her powers and duties, which she's
Doing now.
can do legally.
Yep.
Whatever happens, happens. If down the road, Mr. and Mrs. Kane say, you know what, Laurel has moved away and she's not here and whatever, we're going to change the trustee. It doesn't make null and void action that has been legally taken prior to.
Correct. It doesn't. What he's saying is he's worried about this not being the most recent document for the trust. If I can just, is that about correct? In part, okay.
And that she has not granted a power of attorney.
To some, right.
What I'm finding out really for the first time is that this is the first time Ms. Quirk is really hearing about this agreement. And
Okay,
she didn't negotiate it.
all right.
And she didn't give anybody the power to speak on her behalf in negotiating this agreement.
Right. And even if she had said she's not necessarily in agreement with it, but she's going to go as trustee. They're asking her to do this, so she's going to act on that behalf. If we can boil this down and make it as simple as possible, which it's not getting simple anymore. You're worried about not getting paid for their half of the obligation. She's worried about you coming after her personally in Rehoboth if something down the road goes wrong
With the trust,
with the trust paying for this.
correct.
Okay, so if this is a one-off, meaning this is a one thing, the fence, that's it. We're dealing with one issue right now. We're not dealing with an issue 6 months from now. We're dealing with this issue. It's $900. They cough up 450, you cough up 450, and we're done with this particular issue. You can remove individually because you're now paid. Removing individually addresses her concern of, I don't want you coming after me in Rehoboth. Your concern is not getting paid after the work is done. They say, all right, I'm going to front load this $450, or even say, I'll give you an extra 50 just to make sure in case it runs over by 100. Here's $500 or 400, whatever it is. And now your concern of not getting paid is off. Her concern of individually is gone. So both of those concerns are gone now. And we are on a one-off situation, not a future situation, not something 6 months down the road, not 18 months down the road. One issue right now.
All right, Mr. Day,
Yes, sir.
on page 1, line 2, I will remove 2 words individually and on page 3, the signature line 4, I will take out her signature individually. And I would like today to be posted with the fence viewers, a check by the trust, $450.
Okay, so just to follow what you said. Nancy, are you following you're crossing off what he did?
Yeah,
He's saying he would-
after Mrs.
Page 1, line.
Yeah, I got
2.
that one.
Page 1, line 2, yep,
The word Massachusetts,
Yep.
individually and.
line out individually and
On the
Perfect.
signature page.
Page 3. under Laurel Quirk, comma. Line out individually and
And you're willing to do this if the 450, if they come up with the $450 and
Ms. Quirk signs today.
Ms. Quirk signs today.
May I ask, I guess Valerie, do we have a ability to hold funds?
How would that work?
I would have to check. I don't think we.
No.
I don't-
Mr. Moore,
Yes.
Valerie could just hold on to the check without making a physical deposit.
Yeah,
You're okay with that?
yes, I am.
Laurel?
Yeah,
Okay, so that means you'd have to come down before we close today and write a check for $450 and we'd hang on to it?
sure.
And we can cross you off individually and in those two spots that Mr. McKeon
Yes.
mentioned.
Yes,
Does that work?
yes.
That works for you? Mr. McKeon, that works for you?
Yes.
That works for our board? Does that work for you, Nancy?
Fine with me.
If I may. Ms. Quirk is the trustee. Only she can act on behalf of the trust.
Right.
She's signing a document here that she has not issued any power of attorney to anybody to act on behalf of the trust.
Right. So what she does is legally binding.
I would respectfully request that only future dialogue and communication between this committee on behalf of the trust go with Ms. Quirk.
Please.
And any representations about the actions or intentions of the trust only come from Ms. Quirk and none of the
Back and forth.
occupants of the premises.
Well,
Who apparently have never been given any permission by the trustee to speak on behalf of the trust.
okay, so we'll boil it down to that. Is that- Laurel, are you-
please.
Ms. Quirk, are you
Yes.
okay with that?
Yes, please.
Okay, since you're responsible for it.
Yes.
We should go through you for communication.
Correct,
Funnel everything through you.
correct.
You can then dispense information back to the trust folks and we
Yep.
do that. Okay.
Please.
Bill, are you on board with that? Mr. McKeon? I mean, not McKeon, I'm sorry, Mr. Moore.
I won't take offense to that.
I was gonna say
Yeah.
Bill, but then I had to identify which Bill I was talking to.
Yeah, that's fine.
Okay,
Okay, yeah.
okay, so Mr. McKeon signed this document, we crossed that stuff out. I have a copy of it here, I don't think this matters anything to us, but because that's the legally binding document there. So Mr. McKeon signed that. Laurel, if you could just get down here today before what time we close and what time are you there till, Val?
Excuse me, I'm here till 5:30 today.
You're
Okay,
there till 5:30,
okay.
Dayton Town Hall, you know where that is?
Yeah.
Okay, super. Okay, and then we'll,
And I just want to know, do I get a copy of this document as well, just to have on file?
yeah, she'll make copies for you in the office, absolutely. When you come down with the
Okay.
check,
So I'll make checks, copy of the check for you and attach it. for
Okay,
you.
great.
Thank you, Mr. Chairman, Madam Clerk, Mr. Easterday, Merry Christmas.
Thank you.
Thank you all.
Merry Christmas.
Thank you all.
Okay,
The one that's signed.
thank you,
The
Laurel.
one that's
Thank
signed.
you.
Okay,
Sorry for any
Merry
confusion.
Christmas.
Merry
No
Christmas.
worries, that's fine. We work through it. That's what we do.
Thank you.
Thank you.
So,
Thank you.
do we have Kuchenbauer or Bertos here?
They are not.
Nobody else is here. We're done. Yeah, thank you. Have a Merry Christmas.
Thank you.
Okay.
Thank you, Marguerite.
Yes, thank you, Bill.
Sorry I couldn't be there in person. You don't want me there right now. I'm like the bubonic plague.
Do you have a mason? Or you have agreed on a mason or he's got a mason?
He's got a mason.
Okay,
God
all right.
forbid, if I had one, it would be right.
So we received a communication from Mr. Kuchenbauer about, surveyors he's contacted and such.
Okay,
I'm growing impatient with this. How do you guys feel about it?
I didn't hear you. You're gonna throw what?
He's growing impatient.
Oh, growing impatient. I'm sorry. Yeah, I mean, we can't act on that feeling.
Well, what I'm saying is that I think that there's no reason why we can't get a surveyor, at least, if he tells us that, we can't get to you till June, that's what it is, but to say, oh, I'm still looking for somebody and I haven't come up with somebody yet. I'm not convinced of that. How do you
Okay.
guys feel?
Well, yeah, I don't know. I guess I was a little indifferent about that one way or the other, but I don't know. I don't know
Well,
what
my
to tell you.
concern is that Didn't they say that the properties had been surveyed and there was a difference of opinion between the two surveyors? Didn't we hear that initially?
No, the Burdos family had a surveyor done or surveying done. And their surveyor says that the marker is off by a lot, like 6 feet or something like that. And so the question is, whether the Kuchenbauers are going to get a surveyor to either confirm or rebut that position. And so that's where we're at right now, is the Kuchenbauers are supposed to get a surveyor, but they're not doing that. I mean, this has been going on for months now. So
I mean,
I'd like to,
what recourse do we have here? I mean, if he can't find one, do we order him to find one by, next month? Or, I mean, what can we
I
actually
would
do?
say that, yeah, we order them.
If he doesn't
to
find one within a month, then we got to go by the one that's already done. Right? I mean, if he doesn't find one by, let's say, next month or next meeting or something, then we got to go by what's actually on record
Exactly.
and done already. by a
Exactly.
licensed
I
surveyor.
want to see, and I'm not saying it has to be done in a month. I'm
Right, he
saying
has
I
to
want to
find
see that he has one and he's on the schedule
Okay, yeah, I think that's fair enough, just to move it along, because otherwise it
to
could
move it
take,
along.
yeah, forever, okay. So what's a fair amount of time? A month? 2 weeks? When's our
Well, we
next
got
meeting?
3 weeks to our next meeting, so I
All
would
right,
say
so we
by
gotta
our-
notify, okay. Yeah, 3 weeks. He's got 3 weeks to at least get somebody scheduled to go out and do it.
correct.
Okay. I mean, the holidays are in there, so it might, at least it gives you 2 weeks. I mean, it's only 1 week of a holiday, so 2 weeks to get something scheduled, even if it's like you said, March, April.
So you said to him.
I think that's fair. Is that fair, Nancy? What do you think?
Whether or not we're being played is a huge question. When I read this diary of attempts, November 18th to the 28th, he contacted 4 other surveyors. Mrs. Wilson, would you get in touch with Mr. Kuchenbauer, the son?
Yes.
Ask him who the 4 were he contacted, because he came to our meeting and asked us if we could recommend somebody. And we said, we can't recommend. We can tell you surveyors who've done work for the town. And we referenced a company in Middleborough or Lakeville, and he hadn't contacted them. So I want to know if, are they one of the 4? Who are the 4? Telling me you contacted 50 and nobody came. You told me all the other ones on this list, but the last ones, when you came to us and we gave you a name, not a recommendation, it just says 4 others. Well, who are they?
Well, so to your point, that's what Bill is saying. Bill's saying, listen, whether it was 4 or not 4, we're not going to be game playing. So if we put a time frame on you, you got 3 weeks. You can't play games anymore. If you are playing games, you can't play anymore. Then you got to decide on somebody. So that moves this forward. It puts the onus back on him.
Well, that's part of this. I still want to know who the 4 were. But the other thing too is, in all honesty, if after 3 weeks he comes back and says, I still don't have anybody, this thing,
Then we got to go by the license, there's a licensed surveyor that did the work already for the other party. Then we're going to have to go by what's there now because he hasn't gotten one. He hasn't even scheduled one. That's the point. I mean, we got to move this forward.
well, we
can't
think
go on.
that's the case.
Well, we think that's the case. The other way, putting 3 weeks on it eliminates that being the case.
So if the decision is made by the board, since you haven't gotten anybody, even though you said you've been trying all this time, last April.
Right.
Um,
You get 3 weeks to schedule.
we're going to order that the existing survey that shows the property line is in the wrong place and it belongs further north, which would give more property to the Berta side of the.
To the other side, right?
And he refuses. We're back to where we were.
No, what we're saying is, if you don't get, this is what I
That's what-
think
I
we're
just said
saying,
that.
Bill.
I
right?
just said that.
If you don't
I
get somebody
follow
else
that.
scheduled inside 3 weeks, we are accepting the one that's already done.
All right.
And that's your neighbor.
All right. But it doesn't stop there. Because put yourself in the position of him, the property owner who's going to, let's say,
Benefit.
he's going to lose some property because we're going to take the survey of the neighbor to the south, which means the neighbor to the south will gain
Would
a
benefit
little bit of
from
property.
6 feet, correct, or
Okay.
whatever the difference is.
at that point in time, again, my position is land court guys, town is not going to order when one truly disputes based on whatever records he has. That's my land, that's not my neighbor's land. So we're back to the same kind of a mess.
So, yeah,
No, I
but
don't
we're
think so.
back to the, hold on, guys, we're back to the same question. We do not have any right to decide the property boundaries. We
Right.
can tell him to do with the fence. So he can
Right.
move the fence or remove the fence, move or remove, that's up to him.
With fence, that's it. And the
That's it.
survey was taken, and let's say we say, listen, you got 3 weeks to get somebody on the schedule. Or we're gonna accept the survey that's done. Okay, he can't get somebody in 3 weeks. We as a board accept the survey that was done, and we go, okay, here's, we're accepting that. Then it's his choice to say, I'm taking you to land court, then we gotta do hands off. Wait till land court's done. That would be his next move.
Just taking down the fence doesn't solve the problem. Because the
Correct.
line
But
problem
actually,
is still there.
actually, you know, that is the point of the Fence Viewers Association. He does have to move or remove the fence. They can argue in court afterwards, that's fine, but we have control of the fence today. Immediately. There's no delay on that.
So we're giving them some more flexibility and more time to get a survey scheduled. Not necessarily done, just scheduled. And if not, we've got to make a decision and move forward because that's what we're here for. So,
Otherwise, we're being strung along.
correct. So I think this puts the onus back on him to just get one scheduled. And then if it ends up in land court and we have to cease and desist what we're doing about fence, then fine, but at least it pushes their issue further along.
Okay, the next meeting is Wednesday, January 18th. So I will make a motion that this board will send a letter to Mr. Kuchenbauer advising him that he has until the next scheduled meeting of the Board of Fence Viewers, which is January 18th, 2023, to secure the services of a surveyor for the to survey the property boundary with the birdhouse owner to the south. So what that's my motion, then I'll tell you a little more.
I second the motion.
Okay,
Motion made and seconded, discussion.
yeah, so what I'll do is draft a letter and email it out to you and get back to me with any changes. And I'll get it prepared and have it at the Board of Assessors office so you can sign it at your, when you can stop in, and we'll get it in the mail and go from there.
Okay, all in favor?
Aye.
Aye. Motion passes unanimously. Okay, is there any other business?
I don't see it. No new business, no public input here. No correspondence. Okay,
Motion to adjourn?
second.
All those in favor?
Aye.
Aye.
Adjourn.
Okay.
Okay, so what does Stephanie give me here? I gotta.
All right, so we got to end this
You just
meeting. Stop
Stop,
recording.
can you just stop recording, please?
Yeah, so I just want to make sure I know where that is. Is it stop video, Bill?
Yeah, no, it's stop. I think it's the upper left-hand corner is a little thing that says cloud recording or something like that.
Right there, Lynn.
Oh, right there. Okay, so that's. Are you sure you want to stop recording?